Hi, I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. On this podcast, we are going to be discussing the new SEC cybersecurity rules. As listeners of this podcast know, U.S. regulators continue to jump into privacy and cybersecurity at a rapid pace. In recent years, we have seen new and existing U.S. regulators and law enforcement agencies at the federal, the state, the local, industry level all expand their regulatory domain into the area. And if it's possible, they are perhaps more interested in cybersecurity than they are in privacy. And so we're seeing agencies at every level of government, from CISA to New York DFS, from the FTC to California's AG, to set requirements, issue guidance, and engage in cyber enforcement actions. From my perspective, the result is a chaotic swirl of uncoordinated cybersecurity requirements that companies are left to figure out in an environment where the stakes are high and threat actors are evolving really quickly. And maybe there's an argument that perhaps the stakes are highest for publicly traded companies. And I think the SEC may agree and has long, as a result, been talking about cybersecurity for publicly traded companies. And now they have taken another step and actually published new rules that are even more aggressively setting standards for the cybersecurity area. And that is what we're going to be talking about on today's podcast. I'm really excited to be joined by three of my partners, each of whom spend a significant amount of time working in this area. John Beckman, who leads our SEC practice, Allison Holt who leads our cyber litigation practice, Paul Otto, who's one of our leaders on cybersecurity within the firm. All are joining. John, Allison, Paul, thanks so much for joining the podcast. So John, maybe I can ask you as being the SEC expert here, can you describe how the SEC has been approaching cybersecurity in the past before they promulgated these new rules?
As Scott mentioned, I'm an SEC disclosure lawyer, so my focus is on disclosure at public companies. And as Scott mentioned, the SEC has long been interested in making sure that public companies disclose material cybersecurity incidents. And their view is that companies are under-disclosing, right? So there has been an effort. The first effort was in 2011, where the SEC put out interpretive guidance that basically was trying to encourage companies under their existing rules, without changing any rules, but under their existing rules, to say, here is how cybersecurity fits in. You already have to disclose risk factors, right, in the risk factors section of the Form 10K, which is the annual report. You also have kind of a financial analysis section called MD&A. And the SEC went to great pains to explain how material cybersecurity incidents might be disclosed under the existing rules. That was way back in 2011. People looked at that and they said, well, we understood that, and yep, get it. And, people kind of moved on. 2018, after a fairly massive cybersecurity event, the SEC put out new interpretive guidance, reiterating a lot of things it said in 2011, and then focused on, hey, companies, you really need to disclose this stuff sooner. Right. What we've noticed is that companies are waiting a long time, and the cybersecurity incident that is kind of commonly thought of as inspiring this 2018, guidance took, over a month or more to get out their first SEC disclosure on the matter. And the SEC kind of waxed and pined on, how that might be too long and investors need this information sooner. They also talked about insider trading and said, companies shouldn't be allowing their employees to trade when they have this cybersecurity incident that's potentially material that everyone's working on, and people shouldn't be able to sell the company's stock. And so make sure you close your insider trading window. So that was 2018. This rulemaking, I think, is a long time coming. Scott, is at Paul and Allison, I think you all know, the SEC proposed these rules way back in 2022 in our early first quarter and just finalized them this summer, right? So the proposed rules were much more expansive, I think, in a lot of ways than the final rules. And the final rules were kind of pared back, and Paul and others at the firm and I worked on a number of comment letters with a bunch of industry and trade groups to help narrow the rules. And I think a lot of those efforts were successful. So we're going to talk today, Scott, if it's okay, about the final rules and kind of where we are.
Before we jump right in there, I just want to make sure that our audience here, who are often folks who are in the privacy and cybersecurity space, tend not to be the SEC experts and turn to someone like yourself to be able to help explain some of these requirements. The couple of things that you said, though, was that, listen, the SEC has been talking about this for some time. In fact, they already are requiring organizations to do different types of notices, whether that be an 8K or 10K. Can you just describe kind of what a 10K is, what an 8K is, and when those are going to be relevant as we talk about what the new SEC rules are going to look like?
So 10K is the annual report, right? And that is something that a lot of listeners are probably asked to look at portions of. There's a business section, there's risk factors, which lists all the parade of horribles. Most companies now have detailed risk factors on cyber security. And I'd be surprised if many of your readers don't have to review those every year. And that's an annual report. One of the new requirements is going to be about the annual report, which we'll talk about in a moment, but a new section for that annual filing. The other big disclosure regime that we're going to talk about is what we call about a Form 8K. And that's actually called a current report on Form 8K. And that's due within 4 business days of whatever trigger. And there's a list of a dozen things that trigger a Form 8K. And so the real thrust of the new rule is they're going to add a specific line item for Form 8K for material cybersecurity events. So I think that's causing a lot of questions from our public company clients, internal CISO, IT department folks, as well as the disclosure folks, about how we're going to work together to figure out how to satisfy this new Form 8K requirement. So we'll spend some time on that one today. But I think that's one of the big ones that I think a lot of viewers are going to be interested in.
Okay, so if I get it right, 8K is kind of more real-time updates, demonstrate something that's happening in a very short window. And then there is the annual filing, which is a compilation of cybersecurity along with many other areas that are relevant and material to the business, describing how that business operates and risks and issues that the companies are dealing with. Is that fair?
Absolutely. Yeah.
All right. So both of those are relevant. And it sounds like, we're now kind of in the position where for 8K requirements, there are new things that we need to be conscious of. And then there are new requirements for 10K. So maybe you can just give an overview of those key developments.
Yeah, it's important to know, and the 8K also has you can voluntarily disclose things on 8K. And that's what companies have used to disclose cyber incidents to date. So you'll see 8Ks out there about cyber incidents when they're material. So the same trigger we have today, just companies can put it out whenever they're ready. Right, so that's different. Now there's a actual timing requirement, and now that it's actually in the Form 8K, the Form 8K says what you need to disclose. So there's a lot more structure around timing and what's required. Where today, if you had a material cybersecurity incident and you put it on a Form 8K, it would be on a voluntary basis, and you kind of put in there what you think is important to make sure your investors understand what's happening, but you wouldn't have the prescriptive requirements in the rule. So I'll start with, I think, was the most controversial or most dramatic part of the new rule is when, right? And so that's what's going to be the big change, when. So the SEC's rules are based on triggering events for Form 8K. So Form 8K can be, 4 days of entering into a material contract. That's easy when you sign the agreements 4 days after that. For the cybersecurity event, it's going to be 4 business days after the company determines the cybersecurity event is material. So it's 4 days from an internal decision, which is really important, Scott. It's not 4 days from, discovery or the ends or anything like that. It's 4 days from the company's decision. Now, the SEC looked at that immediately and said, wait a minute, don't think you can just delay that decision indefinitely. We're going to hold you to a standard that you can't unreasonably delay your decision after discovery. So no intentionally holding off a meeting and determination, so you can just disclose it whenever you want. But that's a very gray standard, Scott, as you can imagine, applying that and realize, what does that mean, unreasonable delay? But that's the construct.
Scott, I was just going to note quickly, I think that, as you said, John, one of the really big changes was the proposed rule having a much more strict standard on timing without unreasonable delay. That's actually, unlike many aspects of the final rule from the SEC, that's a standard that we've been dealing with, Allison and I, on incidents for years. It's common in many different statutes and regulations. And a lot more of a judgment call, obviously, in the abstract, but not creating that sense that now disclosure review needs to be happening every hour in the midst of an incident.
That's right. That's right. And I'd rather be talking about whether delay is reasonable versus unreasonable than that as soon as practicable standard, right? Like get it out ASAP. That seems sort of unworkable to folks. So I think where we landed is in a pretty good place. It will put some pressure, though, that's not there today. I still think people will be concerned when an incident is significant enough that people are in the organization like, holy cow, incidents, like we need to figure out if this is material. And then the issue then is, and all three of you have experience with this, is then you got to make the filing. Okay, well, so what do we say? We don't even know everything. So the other part, Scott, of the new rule is it's very clear you disclose what you know at the time. And it's focused on the impact to the company as a whole. The financial impact, the non-financial impacts, the impact to the company. So the initial proposal focused on a lot of detail on the nature of the cyber incident. It was very technical, prescriptive. People objected to that in the rulemaking process and said, no, it really needs to be, this is for a non-technical person. This is for a financial investor is the audience. So what is the impact on the company? And if you're in a very large organization, the impact on the company is, could be very small, right? Which might make it not material. We'll talk a little bit about that later. But the impact of the company, both on a financial and non-financial basis. Now, that might be very difficult to describe in the early stages.
We have a triggering event, right? The cybersecurity event, which has its own definition, and that has to constitute material. And the determination around materiality is going to trigger a timeline for us to produce an AK. Also said that there's a standard which we can't unreasonably delay determining whether something is material. And so maybe Allison, Paul, I'm very interested in your perspectives on this. Paul, you made the comment a moment ago that that's a standard that we've long lived with in the cyberspace under breach notification laws at the state level, at the federal level, in the GDPR, right? A number of areas that we've been working with that standard. But as you both well know, cybersecurity events often take a fair bit of time to identify whether something is actually reportable, right? In other words, we may start seeing or smelling a lot of smoke in the very beginning. It's not clear to us immediately whether that smoke is just noise that's out there, mixing metaphors, but we're not sure that we can see a fire. We're not sure that we actually have compromise of data or compromise of systems. So how are you thinking about kind of when in the ordinary course of running these incidents, being able to satisfy that unreasonable delay standard that John was talking about and that we've dealt with for so long?
Scott, I'll start and extend at the risk of torturing the analogy. It's always fraught trying to bring a physical analogy into the digital world, but I'm going to go for it anyways. And the fire analogy, and think about a facility and someone internally, the equivalent of the IT security team, reporting there's a fire in the building, or we think there may be a fire in the building. There are some things that are very much the same if we're talking about a physical fire or cyber attack. If you ask what's the initial sign made you think that that's the case, you can get a pretty clear report. What was observed? What was there smoke seen? Where was it observed in the building? Where was it observed in the IT network or environment? Deviations start very quickly. In a normal physical fire, we probably don't start with it was an arsonist, but in this case, in the digital world, we probably know that very quickly. The signs are immediately alarming, malicious, suspicious activity or suspected malicious activity. In both cases, it will take a little time to know is the fire out, but that time scale is quite different. A physical fire, hours, maybe days in our usual building situation, but the IT and security personnel are often waiting weeks to say with confidence or give the assurance or attestation that the fire is absolutely out. There's no more fire from what this fire started. There'll be an early focus on how did it start and where did it start may never be known in a cyber attack, which is also true in a physical fire. But more likely, unlike a physical fire, that we'll find evidence that the fire started days, weeks, months ago. And there's signs that there was fire damage taking place well before we knew it and going much further back. And then the real challenge is just the overall investigation in our digital fire, in our cyber attack situation, which is the unknowns are more than the knowns for a long time, typically in these investigations. And similarly, giving assurances, is the fire not going to spread to the second floor? Is it not going to get to this part of the network? Was the attacker there or not? That all starts to break down quickly. That people are challenged to give those answers. And that's where, Allison, maybe you have more comment on our usual world of cautioning everyone and anyone involved in incident response to avoid speculation, to be mindful of what's the strength of what we can say, because the firefighting in a cyber attack can go for a long time, and the investigation after can go even longer to really know what happened or piece together and to know what didn't happen as well.
Yeah, two quick points from me on this. One, Paul, on the piece that you were just talking about, something I tell all of our clients is that in the case of a cyber attacker, and using the fire analogy, every single person at the company believes that their stakeholder is the most important stakeholder, and they want to get every single bit of information that they can to their stakeholder, whether we have been able to confirm that that information is accurate or not accurate. I mean, there's a lot of rubbernecking after a cyber attack, and people want to know like what's happening, and businesses want to respond to their clients. And as we're talking about here, they definitely want to be responsive to one of their key regulators, the SEC. And so it is frequently a difficult position for us and for our internal clients to have to tell their business clients, wait, we have to go slow at this and make sure that we are actually providing accurate information, because as I'm sure John can agree with me on, like, providing inaccurate information can be a real problem. And so there's this real tension between being as expeditious as possible, meeting these standards, and making sure what you are saying is so buttoned up. I mean, we've had instances in the past where, week one, we were confident in a given fact. Like everyone was confident in that fact. The forensic investigator, the law firm, the business, everyone. And then 2 weeks later, maybe the fact had a little more gray around it than we realized. And so it's a really difficult balance on, what information we can give folks when. And then the second point I want to make, and I think this might pivot us to what John teed up a minute ago, which is, well, what exactly is material? How do we determine that such that a company needs to provide an 8K filing and this out of cycle filing to tell the SEC about something happening? And one thing that I find to be very difficult is, torturing Paul's fire analogy a little bit more. Like, it doesn't matter what kind of fire you have in your house, like a candle tips over, a grease spot, you're going to treat it seriously and you're going to respond thoughtfully. And it's the same with a cyber attack. It's what our clients want to do. It's how we want them to approach these incidents. And I think one thing our clients are really struggling with is making sure that what we are taking seriously doesn't somehow come off or equate to materiality, because those two things are not the same.
I'd like the fire. I've never really thought about the fire analogy and materiality. It's actually quite useful, I think, visually, right? Because to your point, Allison, a candle falling over, like, you're going to take it seriously because you have a fire that lit a napkin up at the dinner table. Is that at risk of burning your house down and being a material? No, probably not. You're not going to run out and but you're going to take it seriously just like you would anything. And that's a great analogy for, because all companies, all of our clients, everyone we work with, all public companies have some cybersecurity incidents, right? And Scott, to the earlier point, companies are disclosing material cybersecurity incidents today, just not under this regime. When the whole second floor is on fire, it's hard for people to look around and say, we're not going to say anything about that. And what's going to be the challenge now is exactly the point that Allison made, is there's going to be a fog of war. There's going to be not really quite sure what is happening. And then there's this kind of clock ticking about, is it material, is it not material? And then information changing, and that dynamic, it's just going to put a whole nother layer of, I think, complexity, and also coordinating with your internal disclosure team, right? So they got the cyber team internally, privacy, cybersecurity folks, IT, CISO. Then you have your general counsel, your SEC disclosure team in-house, and then outside counsel has both those capabilities. But it's going to be a team effort. And that's the one thing that we've learned in doing these together, Scott, as you know, is that it's not just one person making that decision, right? That is a multidisciplinary internal team, just like we do outside counsel with a cyber person and an SEC disclosure person. We're talking through that. And the other point, and I'll pause for comment from Paul and Allison that we come up with a lot, is materiality, which is what Allison was segueing to, is very amorphous, right? It's material. It's something that an investor would think is important in buying or selling your stock on a given day, right? And so for fairly huge organizations, a lot of these things are not going to be, considered material. But when does it cross the threshold that you really need to tell investors? Because investors are going to think, holy cow, this is like something so important. And the bigger the organization, fairly significant cyber and ransomware payment, millions of dollars, may seem like a big deal, but is it really that important to a $20 billion organization? Maybe, probably not. And that's why there's not a ton of 8Ks today on, I would say, a lot of ransomware incidents that are fairly well contained. That's prescriptive.
John, I want to maybe amplify, I think, something that you're saying that maybe is not well understood, especially within the non-legal audience. Using the word material is not an infrequent, it's a regular word that people could use, especially as they talk with lawyers all the time. Is this something that I need to think about? Is it material or is it immaterial? If it's immaterial, I have time to go on my, and focus on more important things in my day. What you're describing, and I think, Allison and Paul, what you're trying to construct in folks' mind is that materiality is a legal determination that is a very important one for us to make sure that our incident response teams, all of those people who were involved, are very conscious of as we chart a path forward on our investigation and are regularly circling back to determine whether something is material. But it doesn't sound to me, John, and you can tell me if I'm mistaken, that is the role of the chief information security officer to be like, oh, this is material, or, the privacy professional say, oh, this is material because it impacts personal data, or it's the SEC lawyer to say, I've heard that there's a cybersecurity issue. This is material. It sounds to me, the point you just made is that this is really a multidisciplinary, multi-stakeholder kind of team-oriented approach that has a lot of ramifications and thus needs to bring the same level of seriousness to it.
That is exactly correct. And companies already have processes for making materiality determinations, right? There's already, either a committee or it goes to the general counsel and CFO, high level within the organization disclosure decision-making. What's going to be different here is companies are going to need to come up with a specific process for determining materiality for cyber, where it may be done now on a little more of an informal basis. We're going to have a little more formal structure. And of course, the CISO or some of the technical team members are going to need to be part of that conversation, right? Because part of it is, what is the business impact? What's the technical impact? What's the financial impact? There's different people who have perspectives on that and who have the kind of expertise to weigh in, right, on that. So it's going to require financial analysis. It's going to require legal analysis, litigation exposure analysis, right, which Allison works on. And also like cyber, right? People say, what is this event? Like how significant it is to, what's the data, all that kind of stuff. So it is certainly a multidisciplinary. And the point you made, which is, I think, is a critical one, is it's not on anyone on the cyber team alone to determine materiality. They're going to be part of a larger discussion that's going to take into account all those factors in making that ultimate decision.
Yeah, and Scott, I think you highlighted a strong point here, and Allison and I spend a lot of time with the IT, InfoSec, and privacy folks on the reminders around key terms to avoid or remembering what are legal terms of art. Breach, capital B breach is one we've been focused on for years, and discovery, what the date of discovery or when an incident was discovered or a breach was discovered is a very thorny legal issue and may have different answers. And so I think what you're highlighting is material needs to be on the top of that list for various folks involved in incident response, for whatever their roles, to remember not to use that lightly or throw that term around. And going back to our candle analogy and the fire starting there, IT and InfoSec teams, the good ones are acting like the whole house could burn down every time in their response, commensurate with what they're seeing. But if you ask them what the worst case they can imagine at every point, they're happy to spew out a parade of horribles on any type of cyber incident or attack because they know that things can spiral quickly. So it's a danger there as well, that if they're not recognizing the important words, that an early email or summary might throw in the word material in a way that they don't realize if they just said significant would ease a lot of pain for what we're talking about for the SEC, and then what Allison deals with all the time months and years later, and how things are interpreted in litigation and in regulatory investigations.
As listeners know, I love takeaways on this podcast, and I'm hearing several kind of just jump out. And John and Paul, your comments around making sure that teams who may never have had to deal with materiality before from an SEC point of view are now need to be plugged into that process, right? They need to understand what their disclosure committee looks like. They need to be a stakeholder as part of that. And they also need to understand that these are terms not to be used lightly because they have legal implications. Allison, Paul, I want to hear your perspective before we jump into the other category of SEC rules that are proposed relating to the 10Ks. But just before we wrap up 8Ks, this is not happening in a vacuum, right? In other words, the SEC is not the first organization to propose data breach notification laws. We have many of them. And this is another layer in an already complicated and intricately weaved fabric of data breach notification considerations. How are you all thinking about that relationship? And maybe Paul, I'd ask you that question. And Allison, I'd love your perspective on how this relates to the litigation landscape, the enforcement landscape that you are in the middle of on a day-to-day basis as companies are making public data security incidents.
Certainly, Scott, a very crucial aspect of the implications of the rule here. So certainly the 4 business day timeline after a materiality determination is not putting this at the front of the line for all the different notification clocks that we're used to dealing with. There have been 72 hours with GDPR under various cyber insurance regimes, and 2 to 3 business days for other purposes. Contractually, people have seen terms as quick as an hour if they're in the government contracting space. The new CERCIA is going to impose its own shorter clock for certain types of incidents being reported to the US government. Really important difference is everything I just alluded to are non-public filings that those regulators have gotten accustomed to going back to our fire analogy, that there's as much unknown as known. There's very basic descriptions and requirements for disclosure around quickly characterizing an incident, but not necessarily the impacts, not necessarily having to speculate, or certainly not calling the question, is it material, in whatever other equivalent forms as to that regulator. So in other words, a lot of places that very quickly organizations are having to make fast decisions around whether potentially reporting requirements triggered. And Allison and I and others are constantly working to control the narrative and make sure appropriate notifications are made, but recognizing that with regulatory investigations, litigation, and other matters later, that those are all going to be understood as points in time, meeting legal obligations without making those declarative statements. And I think the big difference, and turn over to Allison for this, is now we're talking about a public disclosure that is before the dust is settled and we fully understand, and really under the final rule being asked to speculate, in a sense, what are the material or potentially material impacts in ways that we are advising everyone internally in the early days of an incident to not talk about because it's too speculative and it's only going to be fraught.
I just want to pivot quickly because I don't want to lose sight of the fact that the SEC rules go well beyond incident reporting.
Yes.
And go well beyond kind of what needs to happen within the 4 business days and materiality. They actually establish kind of a whole additional set of disclosure, which, as I understand it, goes beyond things that they've asked for in the past. John, you want to talk a little bit about what now needs to be articulated as part of that annual 10K report that companies are responsible for?
Yeah. And I will say what we ended up with in the final rules is a far cry from, I think, what was initially proposed. And I think is going to be manageable for most companies, but it is going to be something that is not in everyone's 10K today. There are some companies that disclose fairly significant detail about their cyber programs, sometimes in an ESG or sustainability report, sometimes in the proxy statement, but it's really kind of describe what and how you want voluntary disclosure. There is a new item in the 10K that's going to be called cybersecurity. And The focus is again on informing investors, so informing non-technical people. So it's not intended to elicit information for CISOs to compare each other's, programs. Right? It's designed to be a non-technical person to understand cybersecurity risk and risk management at the company. So it's made to be kind of for a reasonable investor to understand and be able to say, okay, this company, this is how they manage cybersecurity risks. And it's a very vague concept. And the SEC asked a few questions like, does it fit within your broader risk management, process? Do you use an external third party to help you assess and manage this? There are a few questions like that. Very early stages. I expect most folks that listen to your podcast who are working at a public company are probably going to be drawn into this process on how do we describe at a high level how we manage risk. Then how does senior management fit into it? Do you have a CISO? How is that? Is there a process? Do you have a quarterly committee? So those are the type of things that are now going to be disclosed. And how does a cyber risk roll up to your board? Those are the things that are now going to be sort of a capsule summary format in everyone's 10K. That is a completely new requirement.
Fascinating, John. And Paul, I'm interested in your perspective on this because cybersecurity professionals, I would say that they probably see themselves first and foremost as individuals who are responsible for managing risk. There are careers that are dedicated to this particular question. And obviously, there are many ways to go about trying to address risk in this area. And it is an area that is rapidly evolving. So as you are hearing about these new disclosure requirements, is it possible to clearly, succinctly, in a high-level way to capture what risk management looks like for cybersecurity? And then maybe I'd also want to hear your perspective is that these disclosure requirements, does this backdoor into saying I have to describe what I'm doing? Do I have to do things differently than I did before?
On that last point, Scott, I think you've hit the nail on the head that a lot of companies, a lot of the clients we're talking to are thinking about this as a bit of a high-level checklist for review of how current practices align. I suspect, John, this is similar to any new SEC rule where anticipating new disclosures, you got to do that checklist. The difference here being we're not talking about necessarily crystal clear guidance on what this would mean, and it's going to look different for different companies. Importantly, Scott, to your question, really in the context here, the broader context, information security leaders have been feeling a little more under the spotlight for a variety of reasons, and this is yet another pressure point. Do they own the risk? Is cyber risk different? Is it fed into enterprise risk management? Is it categorized and monitored the same? Are incidents escalated the same as any other type of issue? There's a lot of things happening outside the SEC space and with the SEC where the chief information security officers of the world are looking around saying, am I subject to criminal prosecution here? Am I going to be pursued by regulators for how I did or didn't act on certain cyber risk, on how I did or didn't escalate certain issues? And some of these new requirements and disclosures are going to put more pressure in that regard, more expectation. In other words, that there are certain kinds of reports, certain kind of risk management practices that companies will wish to disclose and will describe in some way that later is another avenue for second guessing. Was leadership acting in that fashion? Was it handled appropriately? And should they have said more? It's always easier in retrospect when the dust is settled, when we see the full set of what the fire did to say, well, you could have highlighted this or that, but it doesn't feel that way on day 1, 10, or 100. Same is true outside of the incident space. Other types of cyber issues and risks that are identified, vulnerabilities that haven't been patched, or asset management programs that could be better. There's always room for improvement, and everything gets magnified in hindsight when there is an incident or when there is a complaint or an issue that comes to the forefront around how maybe that should have been escalated further, or was it brought to the right people's attention. So I think aspects here are putting more pressure on companies, in other words, to go through that kind of checklist review, feel good about the coordination, and it's actually bringing more stakeholders together, just like as we talked about at the outset, John, educating the privacy and cyber professionals that we talk to more regularly. But those conversations are happening internally much more robustly in the last month because of the new rule.
As I hear what Paul was describing, and I'm kind of thinking about how practices have evolved in this area, obviously there's a lot more to come with respect to how organizations are approaching these new disclosure requirements. As I read SEC risk factors as an example, there tends to be a lot of similar language that publicly traded companies use. Obviously, none of them want to be on an island in terms of how they're describing their cybersecurity risk posture and the various threats. Do you see that there will become a market practice kind of within the disclosure committee about how to approach these? Or do you see that there's more likely to be differences between organizations as they are looking to clearly articulate how they're managing these risks?
That's a great question, Scott. I mean, this is not unlike other areas. Like the SEC had put forward some human capital management disclosure requirements, right? And it elicited 2 sentences from some companies and a page and a half from others, right? This will certainly start that way. There will be the minimalist type of disclosure, and then there'll be much more expansive disclosure. And everyone will look at each other's disclosure after this first year and kind of recalibrate. So there will be some amount of kind of moving to the middle, I believe. Ultimately, that's usually how these play out. These have certain prescriptive requirements that I think are going to make your disclosure different. Like, for example, do you use external third parties? Right? Some companies don't. If you do, you're going to have to say that. And then there's some, talk about how you use them. Your internal processes, right? So companies that have a quarterly committee, cybersecurity committee, will probably disclose that. Do you have a CISO or not? Like these kind of things will be depend on what kind of facts you have. And one thing that we've learned, and actually Paul pointed this out with the client, is some companies have had to produce similar descriptions of their programs to let regulators in inquiries, right? So there may have been an effort internally to do kind of a similar assessment. And so we're working with some companies who have kind of done this for other purposes and are now having to put it in, I would call, SEC disclosure type language and format. But we're starting to work on this with dozens and dozens of companies just now. And everyone's asking these same good questions, like how much detail. And so I think a lot of people are starting with a checklist type format, kind of along the lines that Paul was suggesting, and going through and then trying to craft something that is not too detailed, maybe, but not too cursory.
As I hear this conversation, there's a lot to do, right? There is a lot of planning. There's a lot of kind of looking back at your governance structures, your incident strategies, your incident response strategies, your disclosure committees. There's a lot. I'm going to ask each of you in a rapid fire way, name one thing, just one, that you think organizations should be thinking about and doing in response to these SEC rules. And Paul, maybe I can ask you, Allison, and then John, I'll let you have the final word.
Absolutely. Well, I think I will choose my one as looking at the documented processes and approach to get things into the funnel. And what I mean there is incidents as they're happening. What's the playbook, plan, approach that confirms in writing and in practice that potentially material incidents are getting escalated and brought to the attention of appropriate people early at the appropriate time. And that involves a look at the severity and classification regimes and the incident handling processes and adding some hooks that may or may not already be there, or otherwise making them more robust. And as importantly, and really unusually as part of that getting things into the funnel, the SEC final rule has this concept of related occurrences, related unauthorized occurrences, potentially being material. That was a bit of a change from where they were about individually immaterial incidents in the aggregate, but similar principle. That's going to require extra look at what do you do to get things into the funnel? What kind of processes do you have that you can point to later to show that you weren't missing potentially material things being escalated to the disclosure committee or equivalent key stakeholders?
I'm going to focus on the 10K rules. And I think the key is to make sure that someone like John is helping you think through what you say in your 10K. Because if you have an incident where you have to file an 8K, the SEC is absolutely going to go back and look at what you said previously in your 10K. So making sure that you have some help on those things in a way that maybe even with a fresh set of eyes would be really beneficial.
That's right, because SEC disclosure is often later challenged, right? If you pretend that your cyber regime and you paint it in too rosy of a picture, right? It later turns out that wasn't really accurate. You're creating additional problems for yourself. So my takeaway, Scott, is at least on the 10K, this applies to most companies with a kind of a calendar year, fiscal year for this next 10K. So coming up, which is filed in February or March. So it comes quick. So my suggestion for companies is to start this in the fall and not wait till January to try to do this when everyone's busy on other things, and not try to rush it. So start it in the fall. And I totally agree with Paul. You got to link the incident response process to the disclosure process somehow. Probably already is in ways, but you probably want to take another look at that and potentially formalize some processes for these new 8K rules.
Those are all great tips. And as listeners know, I try not to lie on this podcast, but in this case I did. John, I said I was going to give you the final word. I'm going to take the final word back with this idea of there is probably not a community out there that is better at acronyms than the cybersecurity community. They're very good with using all sorts of acronyms. So here's my final word. That community needs to learn a new acronym, and that's the SEC. So with that, I'm Scott Loughlin. This is the Data Chronicles, and those are your data points.